Hi everyone, welcome to CL-LST. So in this series, we are referring and we are talking about constitutional law. So in the last two classes, we have discussed the basics. Basics of constitution, salient feature of constitution, since Indian constitution is called as a bag of borrowings also. So from where we have got what all features, how the constitution came into picture, whether the Indian constitution is federal in nature, unitary in nature. Then we have also discussed about preamble. So this is something which we have covered in the last two constitutional session. In today's session, we are going to focus on a very important aspect, which is the fundamental right. Now, when we take into consideration fundamental rights, so first of all, why we need to read fundamental rights. So fundamental right is something which forms a very important aspect in your CLAT syllabus. And if you look at the paper, past year paper, if you analyze, you'll see somewhere you'll find all the articles being questions being asked from different articles, or for that matter, even if there is certain information from current affairs perspective, it does have some link with the fundamental right. Whether you take into consideration right to pollution free environment, whether you take into consideration right to equality, whether you take into consideration freedom, like in the first uh, CLAT 2020 paper, that Arnav Goswami passage was also based on freedom. So, and it is not, that was not the only passage. In the first CLAT 2020, there was a question based on obscenity, which is also whether reasonable restrictions can be imposed or not. So, if you take into consideration the current affairs, always there is some idea which is related to fundamental right. That whether this, if there's a question with respect to a particular law, what you need to take into consideration is whether this law violates the fundamental right or not. If you take into consideration reservation thing, whether it is with respect to SC/ST reservation, sub classification within SC/ST, whether you take into consideration EWS reservation, Article 14 comes into picture, which is right to equality. Whether you take into consideration UCC, Uniform Civil Code, again Article 14 is coming into picture, Article 25 is coming into picture. If you take into consideration media trial, Article 19 is coming into picture. If you take into consideration your freedom of speech and expression, Article 19 is coming into picture. If you take into consideration pollution free environment, then Article 21 is coming into picture. If you take into consideration where question has been asked from privacy perspective, Article 21 comes into picture. If there is some practice of untouchability, then Article 17 comes into picture. If there is a issue with respect to, you can say, double jeopardy, self-incrimination, ex post facto law, Article 20 comes into picture. And Article 20 is something which is very much favorite of CLAT. They keep asking questions. So keeping that in mind, it is very important for us to understand what is fundamental right and how we are supposed to read it. So today I'll be taking up certain fundamental rights. So certain articles we can say, for example, when we take into consideration fundamental rights. So fundamental right is something which is being guaranteed by the state. So we need to understand what is state, and then we'll be taking into consideration what is law and how the law shall not be violating the fundamental right. Then we'll move ahead with Article 40. Now, when we take into consideration fundamental rights, so what is fundamental right? These are very basic freedom which an individual needs, or you can say these are the basic freedom that protects the individual and maybe group also from the government outreach. Indian Constitution Part 3rd from Article 12 to Article 35 is covering fundamental right. If you classify the fundamental rights mentioned from 12 to 35, it can be classified in six categories. And when we take into consideration these six categories of fundamental right, so the first one would be right to equality. When we say right to equality, it is being covered from Article 14 to Article 18. Then the second one is right to freedom, which is being covered from Article 19 to Article 22. Then we have rights against exploitation, which is covered under Article 23 and 24. Then we have right to freedom of religion, which is covered under Article 25 to 28. Then we have cultural and educational right covered under Article 29 and 30. And the last one is right to constitutional remedies, where we generally, it is being covered from 32 to 35, but what we read, what we refer, what we focus, or what is right to constitutional remedy, it is Article 32. Article 32, where you move to the Supreme Court, where you file writ petition in case your fundamental rights are being violated. So these are the six categories in which fundamental rights are being given. Then how the fundamental rights are being protected. So the constitution protects the fundamental right through judicial enforcement, government officials, moral commitments are also there. Judiciary keeps a check and balance on the working of the government so that the government action shall not be arbitrary, it does not violate your fundamental rights. The Supreme Court plus the High Court is also having the authority to issue writ. Supreme Court can issue it under Article 32 in case your fundamental right is being violated. High Court can issue it under Article 226 in case your fundamental right plus legal right is being violated. Now, fundamental rights is something which is very basic, as we just discussed. This is very much needed for us to survive, not to survive just like not to just have an animal existence, but to have a dignified life. It is very much needed. But if we take into consideration fundamental right, obviously these fundamental rights are not absolute right, and government can impose certain reasonable restriction if it feels that it is very much needed for the, you can say, to maintain peace, to maintain the public health, morality, national security. All these comes into the category or consideration when fundamental rights are there. And if your action violates any of these things, or if your action falls within the category of sedition, or it falls within the category of defamation, or if it, your statement may be considered as a threat to the uh, national security, or where it is somewhere impacting the friendly relationship with our neighboring country. So in all these circumstances, or wherever government feels that a reasonable restriction shall be imposed to maintain the peace, they can do so. So this is some of the basics of fundamental right. Now, as we discussed, that when we take into consideration fundamental right is being guaranteed by the state. State is one who is giving you the right. So for that purpose, you need to understand what does Article 12 of the Constitution state. So Article 12 of the Constitution states the state includes the government and parliament of India, and the government and the legislature of each of the state, and all local or other authorities within the territory of India or under the control of government of India. So state is the executive, which is government of Union of India and of state, the legislature, where we are referring to parliament and state legislature, local or other authorities within the territory of India, for example, municipality can be there, panchayat can be there, local and other authority under the control of the executive, which is union or the state, or judiciary other than doing the judicial function. So, fundamental rights are a group of rights which are guaranteed to all citizens under Part 3rd of the Constitution. The obligation of protecting these rights lies with the government or the state. Article 12 of the Constitution contains the definition of state. So, government and Parliament of India is basically the executive and the legislature. Government and legislature of each state is the executive and legislature of each and states in India, and all other authorities within the territory of India, or which is under the control of government of India. Now, when you talk about government and parliament of India, so the state includes the government of India, which is union executive, and the parliament. The term state, the term stands to include a department of government or any institution under the control of department of government. For example, income tax department will also fall within the category of state. Then the president, while he is acting in an official capacity, must be included in the term and may be regarded as a state. Then same applies in the case of state also, the government of each state falls within the category of state. Then local and other authorities within the territory of India, as I've stated, municipality, panchayat, all these can be there. Then if, I mean, there has been many questions where, or many cases where these questions have popped up, that what falls within the category of other authorities. So the term other authorities is not being defined in the constitution per se, but through judicial interpretation court have determined or defined, where court have stated that if any authority is working as an agency of the state, if any authority is working as an instrumentality of a state, then it may fall within the definition of state. So, here, when we are talking about agency, so you have read under contract also that whatever is being done by an agent under law, it is deemed that it has been done by the principal. So, keeping that in mind, if anything is being done on the behalf of state, then it will be called as a state. So, there's a test to determine whether a body is an agency or instrumentality of the state or not. So the test includes the financial resources of the state, where the state has is the chief funding sources, then whether the state is having any deep and pervasive control is there, then the functional character being governmental in its essence, meaning thereby that its functions have public importance or are of governmental character. A department of government, if it has been transferred to a corporation, for let's say hypothetical situation, if a government, let's say, is authorized, let's consider a hypothetical situation where government is authorized, or government is the body which will provide you electricity. Now this work has been transferred to a corporation. So in that particular case, the department of government has been transferred to a corporation, and it may fall within the definition of state. And here also, in cases where the state enjoys or an organization enjoys monopoly status which state has conferred, or where the state is protecting it, it can fall within the definition of state. So any authority, if you are considering whether this falls within the definition of state or not, or whether this violates your fundamental right or not, you have to take into consideration certain aspect. The first is if this authority has a separate legal existence. uh, it functions in a definite area also. It has the power to raise fund on its own. It enjoys certain autonomy, like self rule is there, is entrusted by statute or by any law with the function which are usually entrusted to municipalities or any other such organ like panchayat, then such authority would come under the definition of local authorities. Or other than this, if anybody is working as an agency or instrumentality, then it will also be called as a state. Now, the very next question is whether judiciary falls within the definition of state or not, and whether judiciary can violate your fundamental right or not. And this is a very crucial, topic, you can say, because article 12 does not define or specifically says that whether judiciary falls within the definition of state or not. If you look at the definition, it is just saying or under the control of government of India. Judiciary के बारे में कहीं mention ही नहीं है. So if we are taking it into consideration, so when judiciary is doing its judicial function, that means when judiciary is adjudicating the dispute, or where the judiciary is taking into consideration its jurisdictions like original jurisdiction, appellate jurisdiction, advisory jurisdiction, or specially petition also for that matter, in that particular case it cannot fall within the definition of state. And court at many occasions have stated that no judicial proceeding could be said to have violated any of the fundamental right. And if it falls within, or if it is doing something which is kind of while adjudicating the judicial proceeding, it will not fall within the definition. But if we take into consideration the concept called as judicial activism and judicial overreach, so judicial activism, again, I am not going in very much detail, just layman may I'm explaining you that judiciary actively is doing something for the welfare. So there it falls within the definition of state. And there's a very thin line difference between activism and overreach. Overreach is where judiciary tries to interfere in the domain of legislature and executive. So let's say if judiciary has made any law which violates your fundamental right, where the lawmaking power is in the hand of executive or legislature. So in that particular case, it may fall within the definition of state. But if the judiciary is making any law while adjudicating a judgment, it may not fall within the definition of a state. For example, Vishaka guidelines. Vishaka guidelines was a result of a judgment. So here we cannot call it as a state. So it is a very settled principle that if judiciary is doing its work, or where judiciary is doing its judicial proceeding, it will not fall within the definition of state. So this is what does the concept of state involves. So today, other than concept of state, we'll also take up article 13. Article 13, again, we need not to go in very much detail from our CLAT perspective. What we need to focus from article 13 is what is the idea, or what article 13 is talking about. So article 13 basically, it says that any law which violates the provision of constitution, or any law which violates the provision of fundamental right, in that particular case, that law will be declared as void to the extent it is violating the fundamental right. For example, Section 377 was violating the rights, the fundamental right to equality, the fundamental right to privacy. So, entire IPC was not struck down. Only that aspect which was violating the fundamental right, or I mean, only Section 377, which was violating the fundamental right, was being struck down. So, all what does Article 13 says? It says all laws in force in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provision of this part, shall to the extent of such inconsistency be void. So IPC came in picture before constitution came into picture. One example, Section 377 was violating the fundamental rights. So only Section 377 was declared void, not the entire Indian Penal Code. So the only thing which you need to remember from CLAT perspective from Article 13 is that none of the law shall violate the provision of fundamental right, whether that law came before the constitution came into picture, or whether that law was passed after the constitution came into picture. In all these situations, each and every law shall follow the provision given in the constitution, and it shall not be violating the you can say fundamental right, or it shall not take away whatsoever is given from article 14 till article 30. So from CLAT perspective, you need to read this much only. If you start reading you know uh, any other aspect, case laws and all, then that is something which CLAT does not expect from you. That is why I'm not explaining. Otherwise, if I start explaining 13 clause 4, so it includes too many of case laws and all, which is not that relevant from our examination perspective, and you need not to go in that depth also. And if you take into consideration Article 13, Clause 3, this you can refer as to, because it is defining what is law. So just to keep in mind, it says law includes any ordinances, order, bylaws, rules, regulation, notification, customs, or uses having in the territory of India the force of law. Also, it says law in force include law passed or made by the legislature or any other competent authority in the territory of India before the commencement of this constitution and not previously repealed, notwithstanding that any such law or any part thereof may not be there in operation either at all or in a particular area. So this is what basically is defining that what all falls within the definition of state, sorry, is definition of law. And the last one is saying nothing in this article shall apply to any amendment of the constitution made under article 368, cannot amend the basic structure. Just to give you an idea, basic structure can be amended, but it shall not take away the crux. This article 13 clause 4 ka debate is all about the basic structure of the constitution. So fundamental right can be amended. Article 21A was added in the constitution, but the idea, the basic purpose of fundamental right cannot be taken away in any of these circumstances. So this is what article 13 states. In the next class, I'll be taking up article 14, which is talking about equality before law and equal protection of law, and then we'll be also taking into consideration article 19, and if time will permit in the next class, then we'll also take article 20. So these three article is very important. Then obviously other articles are also important, but article 20 CLAT time and again keeps asking question. Article 19 and 14 you always see in news. So keeping these things in mind, we'll take this up in the next class. So this is all about today's class, guys. See you guys in the next class. Thank you.